they most likely will do it for free. And again, they'll need to see your photo ID, a government issued photo ID, not a school ID, but a driver's license, ID card, passport, something like that, so they can verify you are who you say you are. And then a location of a post office close to the clerk of court. This is really for convenience. In most counties, your clerk of court is in the courthouse, and most courthouses are in the downtown region. And most downtowns of cities have a post office nearby, or a branch might be closer to your home. So just keep that in mind. And we say post office because a lot of those like blue Dropbox mailboxes are being removed. There have been issues with those. So I always say if you're going to mail documents, drop it off at a post office so you know it's going to be picked up, and you've handed it either to someone or you've put it in the specific Dropbox at a post office. Okay, so I mentioned in our timeline, we're going to talk about how do you file these documents. There are two ways you can file in North Carolina. You download all the forms. There's a long list of forms, and we're going to talk through them, or talk through the process. We're going to fill in each form on your computer, or in black or blue ink. We prefer, I always recommend typing it if you can. And again, these are things you can do as long as you have web access, internet access. I try not to say do it on your smartphone. If you have a smartphone, it's just really, it gets difficult because everything's just small, and sometimes I even need my readers to see things that are in small font. So you want to fill out each form, then you file it with the clerk of court that we've identified in either your county or where your separated spouse lives. The other option is through the North Carolina Guide and File program. Now, as North Carolina has rolled out the overall eCourts program throughout all 100 counties, they created this e-Guide and File program that walks you through the steps of filling out these forms. So it's about an hour. And honestly, if you've gathered all the information we have on our earlier checklist, this 1 hour interview might not even take that long. But through this online interview, you're not talking with someone, but you're going through prompts, like a survey, if you will, that you plug in all the information, you type it in, and it will auto-populate. It'll fill out all those forms from that long list. It'll auto-populate, and you won't have to type into the actual court documents. This survey will populate that, and then at the end, it will spit them out for you to download. Again, if you have all your information together, it will take much less time. After you fill out the survey, you go through the survey process, you will have a chance to review all of those documents. Excuse me. You'll have a chance to review all the documents before you say, you know, these are final. And then once they are finalized through this Guide and File program, I might call it e-Guide and File, but once that is done, you will be able to download them as PDF documents, portable document files, and then you can print them. When you're done, you can print them multiple times, you can print multiple copies, so you don't have to keep hand filling them out or go find a copier. You just print out the number of copies that we'll talk about, and then you file them with the clerk of court. So we are going to talk about the Guide and File process. There is a file it yourself packet that Legal Aid has for absolute divorce, for simple divorce. And I believe Marissa can put that link to that in the chat, but it's also available on their website. So you can have access to that if you're more comfortable with looking at the documents. I'm someone who needs to look at it, gather my thoughts, my information, and then go through it. I'd like to see the blank documents first. So that's kind of one of my preferences, but we'll still talk through what documents you need and how to fill them out. Okay, so as I mentioned, eCourts Guide and File. This is a free online service that will help you auto-populate your forms for an absolute divorce. I would recommend you create an account so you can save your progress, so you can start and stop, go back to it. Let's say you have some of the information and you want to get started, but you need more time to get maybe your separated spouse's address. You can stop, you can save your progress and come back to it. It will print, like I said, you can download your forms, save them. Maybe I always say email it to yourself if you have like a Gmail or a Look or Hotmail, Yahoo, whatever it is. Email them to yourself so they're saved in your email. If you're doing it on a public computer, and that way you can always go back and reprint. Let's say you spilled coffee on them. That even happens to me. So always, it's always smart and helpful to have an account through Guide and File so you can come back or go back and reprint or edit the documents if you need to. You'll see this screenshot on the left-hand side of this PowerPoint is a screenshot of the first screen when you get to eCourts Guide and File, and then you'll see the link to nccourts.gov, the Guide and File link, and so that will also be the direct link. You can just Google eCourts Guide and File Simple Divorce, and it should take you right there. Okay, so we're going to talk through a simple divorce filing, and we're going to call them blue blood v. blue blood. So we're going to just kind of go through this and see how do I fill this out, okay? Okay, now here's the alternative downloading the forms. Here is the link from nccourts.gov, document/forms. We're going to talk through how do you know which forms to use, right? It gets a little confusing. And if you're not a lawyer or if you've never done this before, you're kind of, out in left field and you need to figure out, what do I do? How do I know which documents I need? How do I fill them out? So let's go with this alternative and let's go through what forms do you actually need to fill out and download, fill out so you can file everything at the clerk of court to move forward in our roadmap. Okay, so first, the forms. The complaint form. Now, this is part of that file it yourself NC North Carolina divorce packet from legalaidnc.org. I believe Marissa will drop the link in the chat. She is very good about picking up on when I reference some links, and so always check the chat that they're helpful links and then bookmark them. Okay, so I'm gonna once I go through the actual list, I'm gonna stay on this page for just a few extra, like for an extra minute, so you can jot these numbers down. And we'll show you a screenshot of where you put in the file numbers, or excuse me, form numbers. AOC CV 100. This is the civil summons form. Now, this is the actual document in North Carolina law that starts the lawsuit. So this and the complaint together will begin the lawsuit. Here's the screenshot from that nccourts.gov forms page that we had earlier. And this red box where it has form number, that's where you put, for example, AOC CV 100. Now, if you want to just do the name of the form, go to that top box where it says contain search keywords, put in civil summons, and then it'll spit it out. And one great thing I love about our nccourts.gov website, they do have forms in Spanish. Most forms are in Spanish to help you understand where you need to put all the information. So it'll give you the PDF documents to download, and then they're fillable forms. So again, if you're on a computer, a tablet, you can type in while you after you download the forms. This is the next form, domestic civil action cover sheet, AOC CV 750. Now, I still include this because our last group of counties just went live on our eCourt system at the end of October. So some counties still require this when you are filing in person. Sometimes they still require it when you're filing electronically. I'm including it here just because I can't speak to all 100 counties in North Carolina. So we include this, and this is literally what it is. It's a cover sheet. It's the cover sheet that goes on top of all of your filings. So it's like an introduction to the court system of what this lawsuit you're filing about. What does it contain? What are the actions, the claims you're making? Went too fast. Civil Service Member Civil Relief Act declaration. It's a declaration now. It does not need to be notarized. This is AOCG 250. This is why in the information gathering step, I mentioned that you'll need to know if your separated spouse has a military service history. Are they an active member of the armed forces? Are they a service member? Are they not? Do you know this? Do you not know this? And you need to figure out, how can I provide this information to the court? And the reason this is a requirement is this Service Member Civil Relief Act is a federal law. North Carolina also adopted it, and it provides active duty service members the right of legal counsel if they are deployed, if they're on active duty, to have legal representation with a lawsuit while they are serving our country. Okay, now this is an optional form, AOCG 106. This is the petition to proceed as an indigent. I'm going to talk a little bit about this a little later, but this is just, jot this down if you do think that you may be unable to pay the court costs to file the lawsuit. And we'll talk about it. The court cost to file an absolute divorce in North Carolina is $225. And then if you are resuming a prior married name or a maiden name, it is an additional $10. So if you are unable to afford those court costs, this optional petition form might be helpful for you. Again, when you do that petition for the petition to proceed as an indigent, asking them to waive any court costs, this additional optional form, it's the CR 226 affidavit of indigency. And this is an affidavit that shows what your income and expenses are and gives you support for this petition of why you are unable to afford the court costs to obtain an absolute divorce. Okay. Now, this is important. Make sure you check with your county, usually your judicial district, but your county specifically, if they have any extra forms that they require. When I mentioned at the beginning, going on the NC Courts website, to find the location of the courthouse where your clerk of court is located. On that page, when you say, let's go to Forsyth County courthouse, you want to find all the information about Forsyth County. Well, you can click into that web page. You scroll down, they have a menu at the bottom that says, has a lot of different links, but the one to look at is local rules and forms on your county's page of nccourts.gov. Because that is going to key you in on any other additional forms that they may require. Now, for absolute divorce, in some of the counties I've practiced in, they don't really have many extra forms, but where that does come into play for absolute divorce is, how do you schedule the hearing? That's going to be in your local rules and forms section. They might have a specific notice of hearing form, different things like that. So just keep that in mind and make sure you check through those. And then you can always ask your clerk of court, are there any documents I'm missing? You can call them, you can take your paperwork to the courthouse to file it, and then they might tell you then, and you might have to make a second trip. So I always say it's always a best practice to look at this section, and then if you still have questions, call the civil clerk's office to get some more information if you have all the right documents. Okay, ready, set, file. So let's talk about the documents, we already talked about which documents. Let's talk about the documents that you'll have to fill out and prepare to file. Okay, so you have your complaint of absolute divorce. You want 3 copies. I typically say at least 1 original and 2 copies. You can do 1 original and 3 copies. The reason I say 1 original and 3 copies, that extra copy, if you believe your separated spouse is going to be difficult to locate, then always have an extra copy. We'll talk about this in a little bit why, but I always say it's always better to have extra copies than not enough. So just keep that in mind. The next domestic action, domestic civil action cover sheet. Again, and I will update this, but eCourts went live at the end of October, and most counties don't require these when you're filing online through e-file and serve. Again, each county has its own different procedures, their own different rules and forms. So always check that local rules and forms page. If you have even more questions, call the clerk's office, the civil clerk's office. They work so hard to make sure when people are at the courthouse, they have everything they need, and they will make sure that if you're missing something, they'll tell you. And one other thing, I'll say this later as well, they cannot give you legal advice. So they can tell you, yes, you have everything I need to start this lawsuit. No, you don't. I need this, but they cannot tell you how to fill them out, where to get it, all of that. They might direct you back to legal aid for these listen and learn clinics. Now, civil summons, at least 3 copies. If you think that you're going to be difficult, the separated spouse is going to be difficult to find, get an extra copy. Now, some counties still require that extra copies. They have 1 white copy and then 2 to 3 printed on yellow paper. Some don't require it anymore. Some do. So again, that's a great thing to check with the local rules and forms. And now that all the counties are on eCourts, I would say, and especially with the new year, check in if you're going to file in January. Check to make sure they have updated their rules, whether they have or not. That might give you some more updated information, because again, 100 counties, we don't have the time to go through 100 counties on these listen and learn. So I want to make sure you have all the resources and options how to make sure you get all the correct information before you go to the courthouse. Now, the Service Members Civil Relief Act declaration, it does not have to be notarized, but again, I say at least 3 copies, or one original and 2 copies, or 1 original and 3 copies, if they're going to be difficult to locate. And then optional, we said the petition to proceed as an indigent, and that affidavit of indigency. Those are the optional ones we talked about earlier. And then you want to make sure you have a copy and 1 for the court file. So at least 2 copies of that one. Okay, so you filled out all the forms, you got all the information, and what do you do now? Okay, you do not want to sign any document early. So you want to make sure, whether you do it through the guide and file and you've gone through all their steps through the interview, you looked at the final forms and you reviewed them, you approve all the final drafts, and then you've saved all the documents that guide and file auto-populated, auto-filled out for you after the interview. Do not sign anything yet. Okay, you want to print out the number of copies we talked about before. And then you want to make sure that the complaint is going to be the main one that you have to sign in front of a notary public. Now, remember, I mentioned notary publics, they can be found at your bank, they can be found at your credit union, they can be found their individual notary services. One common one I often see people using are going to like the UPS store, I believe the UPS store charges about $10, but I always say if you have a bank account or, something with a credit union or any other financial institution, check there first because you might have to wait in line unless you have an appointment, but they should be able to notarize your document for free. Okay, let's say we've got everything filled out, you have the correct number of copies that you need, and you are ready to go to file. Now, you want to go to that clerk of court's office in your county to hand them the paperwork with the court filing fee. And it's what their documents will call it is an absolute divorce. Absolute divorce, no fault divorce. A lot of those terms are simple divorce are used interchangeably. In North Carolina, under our general statutes, the legal claim is called absolute divorce. And as I mentioned earlier, the court costs are $225. And if you are resuming a maiden name or a prior married name, it is $10 additional. The clerk will take all your paperwork. They will assign it a CV, a civil district court file number. They'll file stamp everything, and then they will hand them back to you. Now, I always say when you're going to the courthouse, here's some helpful tips. A lot of courthouses don't allow electronic devices. Now, that's talking about smartwatches, that's talking about smartphones, laptops, tablets. So just keep that in mind that if you have your cell phone or an Apple Watch is common, I have like a Fitbit, so anything like that, you want to make sure you either leave it in your car or you bring a quarter. Some courthouses have lock boxes. And this is, again, something you can also call the main clerk's office and ask, can I bring in my phone? Do you have lock boxes? Or just save yourself the trouble and just leave it in your car for the time being or leave it at home. Also, when you're going to file everything, I would generally say, depending on the time of day, give yourself at least an hour in case you have to wait in line. If you have to look for parking, sometimes there are parking decks that are really close by the courthouse. Maybe they're a block away and you have to walk to the courthouse. So I always say when you're going to the courthouse to file everything, give yourself about an hour to make sure that you have enough time to wait in line, make sure everything is filed, stamped, done correctly. We'll talk about some other steps that you might want to do within that hour, but always just I'm a planner, and I think that's just helpful. And also, going to the courthouse can be stressful, and you want to just ease your mind knowing you have this block of time. You're not going to be rushing somewhere or running late for the next thing if you've planned enough time. Okay. So here we are. We have all of the documents filled out. We took them to the courthouse. We've paid the filing fee. The clerk has accepted all the documents. They've issued the summons. They've file stamped everything. They've given you a court file number. What do we do now? Now we have to serve the defendant. Now, I haven't mentioned this before. I've been saying you and your separated spouse. So whoever is the person filing the lawsuit is called the plaintiff in North Carolina. Whoever is the person, your separated spouse, that you are suing for divorce, they are called the defendant. And I don't want anyone to get too caught up in those terms, because the plaintiff is really just the first person to file. It doesn't give anyone the upper hand or lower hand by being the defendant or the plaintiff. It's just whoever has filed the action, they're the one who started it, started the legal process. So they're going to be called the plaintiff, and the other person, your separated spouse, will be the defendant. Okay, we're going to talk about 3 different ways you can serve your defendant. First is sheriff. I find that is probably the most common way. It's not the most costly, but it does cost. It's $30 to serve a civil lawsuit by your county sheriff's department. The second option is certified mail with a return receipt requested. And I usually keep a copy of those documents, and they're somewhere on my desk. If I find them, I'll hold them up so you know what I'm talking about. FedEx is an option, or UPS, and those are great options. They're just more costly. Are you going to have a FedEx delivered on a Saturday, or a UPS delivered on a Saturday? That's just going to cost a little more. So if they're going to be difficult to serve, difficult to locate, you might want to use a different option. The sheriff's office is pretty successful when you have some actual correct addresses. Certified mail with return receipt requested. I just did this last week, and the total cost was about $12. It was $11 and change. So that's kind of what that cost looks like. FedEx, UPS. I know FedEx, the last time I did it was about $50, $48 and change. So those are just some ideas of what those costs look like. And then service by publication. Our laws in North Carolina, now this is Rule 4 of our Rules of Civil Procedure. It's called service of process. The term process means your complaint and your summons. What does that mean? Why do I have this publication option listed here? Well, one, under our law, you can serve by publication. And let me take a step back. What does publication mean? That's putting a legal notice in a legally recognized newspaper of a legal action that has commenced, that has begun, that has been filed against someone else. In our laws, in the rules, that Rule 4 I mentioned, you have to make reasonable efforts to serve your defendant before you use this publication, you publish in a newspaper. So when I say reasonable efforts, I would suggest a sheriff and a person. So a sheriff, a private eye, a PI, a private investigator, or a service processor. And that's last one, service processor, is kind of what you see on TV, where someone just comes up and hands you an envelope and says, you've been served. So a person-to-person option is one option. A second option, part of the reasonable efforts, is like a mail delivery service with a signature. So usually, if you know they're going to be difficult to find, I just recommend certified mail with the green card return receipt, because the other two options are going to be expensive. Now, if you're trying to serve someone internationally, I recommend DHL. And that one, I can tell you again from recent experiences, is going to be much more expensive. It was about, I think, $130 the last time I tried to do a DHL internationally. And it takes some time, and it may not work. Because with those mail delivery options on the second bullet point, you have to have the actual defendant sign something to say they've received this paperwork. Publication, after, let's say you've tried the sheriff, you've tried the certified mail through USPS with the return receipt, nothing comes back, then you can move forward with publication. For example, in Guilford County, you can use the News and Record, and that cost to put that legal notice in the newspaper is about $200. They may have increased it since the last time I did it, but again, it's probably going to be pretty costly if you have to go through each of the steps to serve the defendant. Okay, now this is crucial. In order to have that service of process that I called it earlier, to have that complete, successful, the defendant must have one copy of the complaint, the file stamped complaint, and one filed copy of the civil summons to be properly served. And then there has to be proof of that service of process in the court file that the defendant was actually served. So I'm going to go through each of the different steps in a little more detail of how does that proof get to the court file, okay? So with each of those options. First, sheriff. So remember I mentioned you need to have your complaint and summons together when you go to the sheriff's department. A lot of times this can be done at the clerk's office. A lot of times the sheriff's office is located in the courthouse. So that might be something else to, make sure you have that information. If you are going to serve by sheriff, you want to make sure you know where is that office? Where do I have to go to make sure I get this to them? You want to go and ask for the civil process department, the civil process, service of process. They may call it different things, but when you say those words, they're going to know what you're talking about. You want to give them one filed copy of the complaint and 2 copies of the civil summons that the clerk has written on that started the lawsuit, and they put on the file number that identifies your case. Okay, so why do you have 2 copies? Because the sheriff will serve, if they can locate the defendant at the address you put on the summons, they're going to give the defendant one complaint and 1 copy of the civil summons. So why do they need the second copy? That's how they get the proof back into the court file. The sheriff will then fill out the backside of the summons, which will say this person was served. The documents were handed to this person this time at this address, and then they will sign and say, the sheriff's deputy of Guilford County, North Carolina, service completed on, what is today? December 14th, 2025. And they will put that back in the court file. As I mentioned before, this is a $30 fee to the sheriff's department unless that fee is waived. Always just double check if you have that petition to sue as an indigent. And if that petition is granted, you want to make sure that they are aware of that waiver of the court costs. Okay. So, as I said, the sheriff's deputy who serves the defendant will note the time, date on the back of the summons, and who did they hand the documents to. And then they will send that back to the clerk's office. Now, you can call the sheriff's department to check on when the defendant got served. And I'm going to talk to you why this is so important. Why is that date really important? And how when you call the sheriff's department to check on this, how do they know what case you're talking about? Well, remember when I mentioned that when you file all your documents, the clerk of court will issue a file number, a CV, a civil file number. That is the identification for everything pertaining to this lawsuit. So it's really important to make sure you have a note of that number, save it on your notes app on your phone, or write it down and keep it in your wallet, just so you have easy access to it. So if you do need to call the sheriff's department, let's say 2 weeks after you dropped everything off to see has the defendant been served, that they're going to ask for that file number. Okay. Why are we going to need to know that the defendant was served? They have a certain amount of time to respond to the lawsuit. And after that time has expired, that's when we can move forward in the next step of our original roadmap. And I'll talk about that once we talk about the different types of service. Okay, certified mail return receipt requested. And I don't think I can locate the copies of those, but I'm still going to talk through the process, okay? Okay, so you want to put a copy of the complaint and 1 civil summons, so the one the clerk filled out with the file number, you want to put those in an envelope addressed to the defendant, okay? And once you do that, you want to make sure you are at the post office, and if you are not familiar with certified mail, ask the postmaster, the teller at the desk, I need a service with certified mail return receipt requested. Okay, here is a copy of, maybe you can't see it, but it's like a green and white slip with a barcode. It has a tracking number, and you fill it out with who it's going to be sent to, and the postmaster, the person at the post office, will fill out the different costs. But the important thing is it has your tracking number, and that's how you can check online to see if the mail has been delivered and the defendant has signed the return receipt, the green postcard, to give you that proof of service. Now, the green card, you want to fill it out with the defendant's name and address for the certified mail and pay the fee. The green card will come back to you. You want to make sure you put your correct address on there because it'll be mailed back to you with the signature and the date that the envelope was received by the defendant. You want to keep the record of the date that's listed on that green postcard that comes back to you. Because again, it's going to be very important to have that green card with you, but two, we want to know what that date was because it's really important so that they know that when does their time to respond to this lawsuit expire. Okay, so let's say you have done affidavit, or excuse me, you've done service by certified mail. Even if you've done it by UPS or FedEx, you want to make sure that you have an affidavit in your court file to say, I am the person who is signing this in front of a notary, that I swear on the Bible or I affirm that all of the information here is true and that this document, the summons and the complaint, was mailed to this person, the defendant. It was mailed to this address, and on blank date is the date they received it. And then you want to make sure you fill this out. And on the left-hand side, this is an example from the File It Yourself packet. And it'll have, all of your information here about, your signature, your printer name, your address, telephone. Sometimes it's helpful nowadays to put your email address if you have one. And then at the bottom is the notary block. Now, where it says plaintiff signature in the sign today, do not fill that part out. You can go ahead and print your name, your address, and all that contact information, but you want to make sure that you sign it once you're in front of a notary public. And with this document, with this affidavit, you want to attach the green card, that green postcard that comes back to you after the defendant has signed for the envelope. And then I often say, as good measure, to print out the tracking history from USPS.com. You can just Google USPS tracking, put in this the tracking number on this little green sheet, and it will pop out the full history. Print out the full details, attach the green card to that, and then they often say don't staple, tape. And then you want to take this and along with your civil summons, the original civil summons, and you want to file both with the clerk of court because they want to make sure that the defendant has actually received proof and notice of this new lawsuit that has been filed against them. Okay, now here's a different option I'm going to talk about for service: an acceptance of service. What does this mean? Now, let's say you and your separated spouse, you just are no longer in a romantic relationship and you just both decide, we just need to legally end this marriage. And if you can communicate, and if the defendant, your separated spouse, is willing to go to a notary, I think an acceptance of service is a great idea. It's pretty efficient, and this only costs your defendant, your separated spouse, the cost of a notary, or again, they can go to their bank or financial institution to have it notarized if they have an account there. This is just saying that the defendant will fill this out. You want to make sure you fill the top part out, the court file number, the county, the plaintiff name and defendant name, and then they fill out the bottom in front of the notary. Now, if they do this, again, you want to make note that this blank day of blank month 2000 whatever, you want to make sure whatever date that is, you keep track of that because that's the date of service. You want to make sure, like I said in the other two options before, it's really important to know that actual date they accepted the paperwork. Now, publication, I briefly talked about this. This is a means of last resort. Remember, our laws say you have to take reasonable measures of service of process before you go to publication. What does reasonable means mean? You've attempted service by sheriff, certified mail to the last known address of the defendant. What if you can't find the defendant and you've tried all these things? Search them on the internet. Contact family or friends of your separated spouse. If you have friends in common on Facebook, I've had people find an address that way. See if you can find any information with the DMV. Private investigators. Now, private investigators do cost money, but they have been pretty good about locating or identifying the last known address of individuals. So these are just some options to locate the defendant first in attempting sheriff service or certified mail return receipt before you go to publication. Now, if you go to publication, this is also one of those like real life tips. Contact the clerk of court, contact the clerk in the civil division, or if your county has a family court division, contact that office to see, do they have any local requirements before using publication? Sometimes they'll say, we need to have, at least two different attempts before we'll accept publication. They're not lawyers. Remember that what I said earlier, they cannot give you legal advice. And so you're probably going to have to, make sure that you've gone through the local rules and forms and ask any questions of any local requirements. Okay. Next, we're going to the next part of our timeline, our roadmap. Entry of the judgment of divorce. That's the official name. And there are a couple of different ways to have your judgment of divorce entered. And when I say entered, that's not just when the judge signs off on it. This is going to be when the clerk of court file stamps it. That's what it means to be entered under North Carolina law. Judgment of absolute divorce before the clerk. Let's say you have the acceptance of service and the defendant's 30 days to respond has expired. They didn't file any response and you're at day 31. A judgment of divorce before the clerk is a great option. Another option is an uncontested testimonial divorce before the judge. Now, I'm going to talk about the second option with like a helpful tip. Okay, the procedure for an entry of an absolute divorce will vary. It may vary, but from my experience, going from Forsyth County to Rockingham County to Alamance County to Mecklenburg County, all across the state, they have different procedures, different scheduling requirements. So if you are trying to figure out what is that specific county's requirement, I would say, again, call the clerk of court in the civil division or the family court division to determine what are their requirements to get this scheduled. Will they accept judgments of divorce before the clerk? Some counties don't. So you, again, start with the local rules and forms page on your county's website on nccourts.gov. We're going to talk about a testimonial divorce hearing. We're going to talk about this option because it typically is the more common option. And in those counties where they don't do clerk's divorces, that number one from the previous slide, this is going to be your option of how to get your judgment of divorce entered. Okay. I said this briefly and I alluded to this this 30 days. So you have to wait at least 30 days from the date the defendant was served before you can have a hearing on an absolute divorce. Now, when I say at least 30 days, it's kind of like that at least a year separation. On day 31 is the first date you can have a hearing. Okay, so with that 30 days after the defendant has been served, they do have an option to extend it for another 30 days. So you might be looking at day 61 instead of day 31. I don't find it very common, even when there's an attorney on the other side, to have an extension, but sometimes it happens. So I just want to make sure I briefly mention that. So let's say there's no extension of time, and on day 31 or after the first business day, I say business day, we're coming upon the holidays. So the first day the courthouse is open after the 30th day, you want to contact the clerk's office to figure out what date can you have your divorce hearing? What day can it be scheduled? Generally, you'll need to file the following documents. And these are, again, more common terms for these, but you want to make sure whatever they call it in your county, you use the appropriate form and appropriate title of the document. Calendar request and notice of hearing. A notice of hearing has a filing fee of $20. So you will have to be prepared to pay that at the courthouse when you do file this. But again, if you have that petition granted to sue as an indigent, waiving all the court costs, you won't have to pay this $20. Then you have to serve the defendant this notice of hearing. So they have notice, even if they didn't respond, they have to have the opportunity to have notice of the court date, the hearing for a testimonial divorce. And a certificate of service is just a document that you sign and you file with the court to say that it's your proof. It's your proof that I sent this notice of hearing to the defendant at this address, addressed at this name, on this date, and then you sign it. Now, a certificate of service does not have to be notarized, and you don't have to go through the other service steps as before. Once the defendant has been served through that Rule 4, those 3 different options we talked about before, this can go through regular USPS mail with a first class stamp in a regular envelope. Okay. Again, check with the local clerk of court to find out any specific processes or forms required in your county. Again, I'm going to say it until I run out, my voice goes out. Local rules and forms page on your county website on nccourts.gov should have any specific forms, if there are any, and instructions of what their scheduling process is. Now, if that's unclear to you, I know some counties schedule them virtually on WebEx at 9:30 on Tuesdays. Some do Mondays at 2 p.m. Different counties have different rules and different scheduling. And so that's really important to check with your clerk of court to figure out when is the right date and time I can schedule this. And they have deadlines. They have deadlines to file. So let's say you want a divorce on January 5th. That deadline may have been November 22nd. I'm just giving examples. That's just an example, not based in fact right now, but they might have different timelines of when you have to file your notice of hearing for a certain court date. Okay. When you're preparing your judgment of divorce, the draft, you want to have 4 copies of that document for a hearing before a judge. And we'll talk about why I say 4 copies here, and we've talked about different numbers previously. You will need to mail a copy of each document from the testimonial divorce hearing to the defendant through U.S. mail or through email through the NC Courts, the eCourts File and Serve program. Now, the easiest at this point, I would say, is if you're doing this on your own without an attorney, make sure you, like I said before, have an addressed envelope, have a certificate of service to make sure the court knows you've served the defendant a copy of these judge-signed documents. Just have them ready, so all you have to do is plug in a date and sign it. And always, you want to make sure you have your copies as well. Okay, notice of hearing. I talked a little bit about this before. Some counties only do it on certain days. They have different filing deadlines. Check those local rules and forms page. And if that is unclear, then you want to call. You want to call the clerk of court and just make sure that you've read this, or there's nothing on this, local rules and forms page. Can you help me with knowing what's the deadline for your next absolute divorce hearing date? You need to provide the defendant notice at least 5 business days prior to the hearing date. Now, when it's 5 days, that notice requirement, you do not count weekends or court holidays. So, for example, if your court is closed on December 24th, 25, 26, then you have a weekend, that's 5 days. So you want to make sure you count 5 full business days prior to a hearing date, okay? And then if you do this by USPS, like I mentioned, if you just put it in a addressed envelope, a first class stamp, you want to add 3 additional days. Now, so just make sure, it's really important. I always say, if you're getting really close to this 5, 8 days, counting the weekends or not counting the weekends, court holidays, give it extra time. When in doubt, I think giving extra time, extra days of mailing it as insurance is helpful, because if the defendant does not have sufficient notice under North Carolina law for that hearing, for the testimonial divorce hearing, the judge may not move forward. They will continue the case to a different date. They may remove it from the calendar and make you reschedule it when the defendant has notice. That might be an additional cost. So it's always just better to add in a few extra days as, your insurance. Okay. So let's say we're doing a testimonial divorce. You have your documents. Now, some of these documents are in your file it yourself packet. Some are, again, the certificate of absolute divorce or annulment. That is one that you can get from the nccourts.gov form page. It's AOC CV 711. You want to have your certificate of service of the judgment of divorce. And like I said before, a stamped envelope with the defendant's address on it. And a stamped envelope, very simple first class stamp, one of those forever flag stamps is all you need here. You want 4 copies of the judgment of absolute divorce and at least 1 copy of the certificate of absolute divorce or annulment. And you want to fill these forms out on a computer and print them to take to court. And in the packet, there are sample forms. So you'll want to download these forms to make sure you fill them out correctly based on your information, your soon-to-be divorced spouse's information, and that you have it done in a manner that is acceptable to the court. Okay, so we've got all our documents. We have our hearing. What next? You are in court for the hearing. So what do we do at this point? Like I said, going to the courthouse can be stressful. You can be nervous. How can we get you ready for the hearing so that you have all your ducks in a row? Okay, bring at least 4 copies. They're in your guide and file packet. If you do the guide and file, you'll have these documents pre-populated. And so just make sure you print out enough copies. Okay. When you're going to the courthouse, I always recommend go in business casual clothing. Sometimes I will say, what would you wear to a job interview? What do you wear to church on Sundays? You want to make sure you look, put together. I'm not saying you need to go out and buy, a brand new, professional suit, but you want to make sure, a lot of judges don't like untucked shirts or sagging pants, no hats. If you have religious head coverings, that's fine. In the courtrooms, obviously, most courthouses nowadays don't allow cell phones or smartwatches. So just make sure you are dressed appropriately and, how you want to present yourself to a judge. Okay. Again, leave your cell phones, your electronics in the car or at home. If they have secure lockers, bring a quarter to store your electronics before you enter the courthouse. Arrive at least 15 minutes early. If you're unsure about parking, plan additional time, and then you will have to go through courthouse security. So 15 minutes is is on the shorter end. I'm always, like to be extra cautious. I like to plan things out. So I would say if you know you're going to have to park in a parking deck, and parking decks stress me out, and I've been going to court for 15 odd years, plan 30 minutes. Plan 30 minutes. Elevators may be out at parking decks, or you can't find street parking if you do street parking. Quarters, remember your quarters. But 15 minutes to the courtroom, I think, is a fair time to plan, but plan more time about parking and security. You want to sit in the gallery and wait for your case to be called. Now, the gallery is going to be, there's going to be a section where there's open seating, and then there's going to be kind of like a barrier, and then you'll see two tables where the plaintiff and defendant sit. At the front of the courtroom, you'll have the witness stand, you'll have a judge on his or her desk, and then next to the judge, there will be the courtroom clerks of court, who make sure everything is in order and that courtroom runs smoothly. So just wait for you to hear your name. If you go, if you're like me and you like to get there extra early, bring a book. A lot of people just bring books and wait until court starts. When the judge comes in, you'll have to stand up, and then the judge will tell, or the bailiff will tell everyone to sit down, and then they'll go through the daily docket and call all the cases that are scheduled for that day. So you want to be alert, put your book away, and listen for your name. When your case is called, you want to approach either the judge's bench or the counsel tables. When I say counsel tables, I mean those plaintiff and defendant tables. And if you're unsure of where to go, ask the sheriff's deputy, which table do I go to? How do I need to go to the witness stand? They will tell you where you need to go if you're unsure. And they want to help you. No one is out to make you feel foolish or confused. If you are, just ask. When you're doing your testimony, the clerk of court will swear you in or affirm you, and then you want to take the witness stand. Sometimes for these testimonial divorce hearings, they will do that from the plaintiff or defendant table, so you might not even have to go up into the witness stand. Okay. When you're testifying, I always say keep a copy of your judgment of divorce, an extra copy just for you, one of those 4 copies for you to hold on to, because that will give you all the information that you need to tell the judge of all the requirements under North Carolina law for the judge to grant this divorce. And when you're testifying, speak slowly and clearly. I tell my clients, any witness who's going to testify, if you're like me and you talk fast, stop, take a deep breath, get some oxygen to that brain, and then start talking. Gather your thoughts, look at your notes, then start speaking or answering the questions the judge may have. Like I said, use your judgment of absolute divorce as your guide. Now, sometimes if you're going through everything and the judge might interrupt you, they can. The judge might ask you questions if you've missed something. And there's nothing wrong with that. The judge is open to ask you questions and make sure that everything that's required under the law is on the record so that they can grant your judgment of absolute divorce. Okay, now we're here talking about our judgment of absolute divorce. What is that? What is that document? Now, this is something that will be a sample in your file it yourself packet. And this is just like the front page, a screenshot of the part of the first page. And so this will kind of show you what it looks like, the information that you'll have to fill out, and what other information is going to be needed for this. Okay. It's going to be in your guide and file packet. The main thing you'll probably have to fill out is the file number, because that will be assigned after you file the lawsuit, after you filled out everything in guidance file. So that top right where it says file NO period space CVD space, that's where you'll have to put in that court file number, because that's how they will identify which lawsuit this is. You want to make sure you have those 4 copies with you. If the judge grants your divorce, they may ask you for this so they can sign it in person. They may ask you to have it ready for the clerk of court to upload it for the judge to enter into the e-court system. And then once this is granted, once the judge signs it, it's entered by the clerk. They have that file stamp at the top, and that file stamp will say, you know, the date, the exact time the judge or the clerk entered it, accepted it. And then you'll get your file stamp copies back. Now, when you get those file stamp copies back, remember I mentioned you want to have an envelope ready with that certificate of service so you can mail a copy to the defendant via USPS mail. And so this is why I said at the beginning, it's really helpful to have an idea where the closest courthouse, or excuse me, post office is to the courthouse or to your home. That way, on your way home, you can do it right after you leave the courthouse, or you can do it on your way home. That way it's just done, and you know it's gone to the mail person who will mail it, take it, and deliver it to the defendant's address. Okay, I mentioned the certificate of absolute divorce or annulment. Now, this is just again a screenshot of what this looks like. The top part is what should be auto-populated when you fill this out through the guide and file forms, and this should be included. Now, again, the file number, you won't have that when you do the guide and file. So that line will be blank, and then at the very bottom you see that black box certification in the center at the bottom. Underneath that is where the clerk of court will fill that out, and the clerk of court will sign it. Whoever is entering this judgment of divorce, after the judge signs it, they will fill out that certification, and they can plug in the court file number as well. Okay, so after the hearing, the judge grants it, the clerk has entered it. What do? They will listen to your testimony. They will see if there's anything missing from the court documents. I have seen sometimes that service member Civil Relief Act declaration, it might be missing, and a judge will either deny your divorce if that is missing from the court file, or they will continue the case to another date for you to have to do a new hearing to make sure, to give you time to make sure that that service member declaration is in the court file. If there's not proof of service, they will continue the case or remove it from the docket to say you need to preserve the defendant and wait the appropriate time before you can schedule it for hearing again. They will take the time to look through the court file to make sure everything is in order and done according to the law. We talked about serving the defendant. You want to make sure you sign and date the certificate of service, mail a filed copy to the defendant, and the filed copy of the judgment for absolute divorce by USPS mail. Regular envelope, first class stamp. I always call them the forever flag stamp. So you always want to use one of those when after you do the original service of the complaint and summons. Now, here's some helpful tips about what else. You've mailed it to the defendant. What else do I need to keep in mind? I always say keep a copy of the filed entered judgment of absolute divorce in a safe location with other important papers. This could be the title of your car, the deed to your house. This could be with your will. You want to keep a copy of this in a safe space where in any situation, let's say you got a name change. This document will also include your name change, resuming a maiden name or a prior married name, and you'll need that to go to the Social Security office, to go to the DMV, to make sure your name is updated everywhere else. I just mentioned this. And so the main thing is if you are going to change your name, resume a maiden name or primary name, you want to get at least 2 certified copies of the judgment for absolute divorce. First one is for the Social Security Administration, so your Social Security card will be updated, and then the North Carolina DMV. I always say go to the Social Security office first to update your name, then go to the DMV, and then all the other places will fall into line, like your bank, your employer, your doctors, anywhere like that where you need to make sure your legal name is updated. Once you have your Social Security card updated and your driver's license or your photo ID, passport, that's something to think about getting updated if you've did a name change, and they need a certified copy. And I will say before I close this slide, the court cost for a certified copy is $3, and if you have that petition to sue as an indigent, where it waives all your court costs, that $3 charge will be waived. So just keep that in mind. If you do have a name change, it's really important to get a certified copy, at least one. I say 2 to be on the safe side. So that completes our presentation today. I went through a lot of information. And again, like I promised, Legal Aid's phone number and website are listed on this slide. And I'll keep this up during our Q&A session. And now I will turn it over to Marissa to help me identify the questions that have come in through the chat, the Q&A chat, or on Facebook.
Awesome. And so if you have a question, you either need to type it into the Q&A box on Zoom or post it in the comments section on Facebook. Not seeing any questions at the moment, but gonna give it just a second here to see if any do come in.
Okay.
Again, if you have a question, you can't unmute in this form. So if you have a question, you need to, for those of you who have your hands raised, you need to type it into the chat. First question, what types of questions will a judge ask someone during their testimony at the hearing?
Okay, great question. So when you are looking at your judgment of divorce form, they will, if you don't provide that information, you'll have to say, I've lived here, or, I'm a citizen and resident of North Carolina, Mecklenburg County for at least 6 months, or my spouse, the defendant has. Then they'll add, then you want to go through the questions or the lines in the judgment of divorce. If the judge does not ask you questions, you can just read, essentially go through all the information on your judgment of divorce as a guide of what you need to say on the record. If you miss something, the judge will ask you questions like, when was your legal date of separation? So what was the last date that you and your spouse lived in the same household under the same roof? Then if you miss your date of marriage, they'll ask you, when did you get married? When will you where did you get married? They might ask some of those questions. They'll ask, have you lived separate and apart since that date of separation? If you have not talked about how you serve the defendant, they might ask you that. They might ask you, do you have any children? A lot of times I do see judges ask if you have not put, we have no children born during the marriage. If you don't include that, they might ask, do you have children? Do you share children with the defendant? Those are some of the questions that I commonly see judges ask.
Gotcha. This question might be a little more complex. And I'm not sure if you know anything about this. Someone's asking, how can they separate, I'm assuming, file for a divorce without being accused of abandonment? I don't know if that's something we can answer in this forum, but I will let you
I
take a stab at it.
I think that is going to be a more specific answer, which I don't think we should be able to answer during this time. But abandonment is a little more complex in terms of how abandonment is a factor in other areas of law. So North Carolina is a no-fault divorce state, and the requirements for a no-fault divorce, absolute divorce, simple divorce are living separate and apart for at least 1 year with the intent of one or both spouses to no longer live as husband and wife. So under North Carolina law, those are the requirements. And at no time during that 1 year have you resumed the marital relationship. Now, abandonment is a form of marital misconduct. Again, other statutes in North Carolina law define what is abandonment, what is marital misconduct, and those are factors in different legal claims. It is not a factor in absolute divorce. So for abandonment, you may want to talk to an attorney to figure out, are there other legal claims that abandonment may, you know, be raised against me if I leave the house.
That was perfect. Loved it. And then I think someone's just asking for you to clarify that separate year and 1 day is like two different addresses. Just maybe go over that again.
Yeah, so to legally separate, so what we say, let's say the marital household, let's say you live at 123 Main Street. One spouse or both spouses have to leave 123 Main Street and live at two separate addresses for at least 1 year and a day. So either one person moves out, or let's say 123 Main Street, apartment A, your lease ends and you decide that at that point we're not living together, we're ending this relationship, we're going to legally separate, and you move into two separate households. Or you go move in with a family member, you leave that marital residence, and that's physically leave. And so I think that might go hand in hand with that abandonment question. And so one of the ways to make clear that you're not abandoning or that you're legally separating, and remember that requirement is one or both spouses has the intent to no longer live as husband and wife or as a married couple. Tell your spouse, I'm moving out because I no longer want to live as husband and wife, or I don't want to hold ourselves out as a married couple because I want to end this marriage. And under North Carolina law, I have to move out.
Someone's asking clarification if they use, I guess, I think they're asking if they're asking if they have the sheriff do service, they themselves then don't have to worry about mailing the documents. Is that correct? Just that clarifying
That
question.
is that is for the summons and complaint. So everything else after that, when we talked about, I mentioned a certificate of service, like the notice of hearing. You have to put a certificate of service and mail that to the defendant. If you go and have that testimonial divorce, you have to serve the defendant with a copy of the judge filed stamped judgment of divorce and a certificate of service. So that initial piece you can do by sheriff, but all the other court documents you file after that, you must do a certificate of service and mail a copy of whatever that document is to the defendant.
Perfect. Okay. I did see a hand raised, so I'm not sure someone else was typing. Oh, what kind of proof does someone need for their separation to prove that 1 year and a day? Maybe some ideas there.
Yeah, so my big examples are and this is again when I have people come to me, meet with me, and they ask me, how do I know if I'm legally separated? Well, my first question is, where do you live? Where does your spouse live? Well, they don't really have a permanent address. They're just staying with different family members, and um friends, couch surfing, how well is that enough proof? Well, do you know that they are no longer sleeping under the same roof as you? If you have that, you can include that, that you no longer share a household. You can say that, this is the date that we have legally separated, and at no time since that date, for at least a year, we have lived under the same household. Now, remember I mentioned the complaint has to be verified, meaning it's signed before a notary public. So you are providing sworn statements in that complaint for absolute divorce that you're attesting, essentially, you're swearing to the judge who will read your complaint to say, I have sworn this under the penalty of perjury that this information is true. So by having those documents notarized, that provides the proof to the judge that this information is correct. You've done this in front of a notary, and then when you go in front of the judge for a testimonial divorce, you will place your right hand on the Bible or affirm, raise your left hand and say, I affirm, I swear that everything I'm going to say right now on the record is true under the penalty of perjury. So those are the things that the court will hold very highly, that you were providing the truthful information in your complaint and in court.
Do both spouses have to sign like a separation agreement for it to be valid?
So in North Carolina, to be legally separated, you don't have to have a separation agreement. The legal date of separation is the last day you both, reside under the same household before you live separate and apart, and one or both spouses have the intent to no longer hold themselves out as married. So a separation agreement, you hear those terms a lot. That is going to be beyond the scope of this clinic. But what I will say is, at the very beginning, when we were talking about your money, is this the right filing for you? If you have property division, spousal support, alimony concerns, I would definitely say go talk to a lawyer to see what are your options to protect that. If I need a separation agreement, what do we include in a separation agreement? They can give you more information about if you need a separation agreement. But under North Carolina law, you do not need a separation agreement in order to be legally separated.
I actually think that answered a couple questions, and I am putting a link to the North Carolina Bar Association's law referral service that
Perfect.
Manisha mentioned at the beginning of the presentation. Hold on, let's see. Let me look at some. Um, okay. If the couple got married in a different state and lived in that state, but has now moved to North Carolina for at least 6 months before their separation, do they have to file in North Carolina and the state they got married?
So most, again, let me clarify this. I'm licensed in North Carolina, so I am only referencing North Carolina law. But if you've met the requirements we've discussed today about the legal requirements under North Carolina law to file for absolute divorce, you can file and be divorced in North Carolina. And under our United States Constitution, we have one of our amendments that says that different states will recognize the orders of other states. So if you're divorced here in North Carolina, and let's say you had a destination wedding and got married in Hawaii, and you want to go on vacation in Hawaii to celebrate the divorce, Hawaii will recognize that you are a divorced person, that you are unmarried. So that's one thing you don't need to file in every state. Other states will recognize this dissolution of the matrimonial bonds. Those are some legal words, but other states recognize a judgment of divorce from North Carolina.
Perfect. And then, um, say the couple has been living, well, not couple, but these persons have been living separate and apart for years. So maybe they don't necessarily know their date of separation. Is that still necessary? Like the exact date?
It is necessary. What I would say is if they like, I'm going to give an example that I think will answer this question. So let's say this couple, they've had this marital relationship, but their jobs are in just two different locations. Let's say, you know, the plaintiff lives in North Carolina, lives and works in North Carolina, has been here for 6, 7, 5 years, and your spouse works in New York City and they live there, but you spend time together, you do go on vacations, you celebrate your anniversary, birthdays, special meaningful days together. But then let's say in that 5 years, you're living physically separate and apart. Let's say, you know, you decided March 18th, 2024, that I just don't want to be in a marital relationship anymore. I've done this for so long and I want my spouse to live with me. And they're not willing to give up that job in New York City to live full time with me. And if you have that intent on March 18th, 2024, then that is your legal date of separation. So more commonly, that living separate and apart is the latter of the two things that occur. Sometimes the intent can be the latter of the two things that occur. So that date you've decided, I don't want to live as husband and wife any further anymore, that is your legal date of separation. And let me give you another real life tip. You don't have to tell your spouse that I no longer have the intent. You have to make that intent. And I do think informing your spouse that you have that intent is helpful as to kind of what I alluded to, where abandonment might be a factor in, spousal support or other legal claims. I think it's helpful to make sure you inform your spouse, even if you're living separate and apart, that, I don't want to continue this relationship like this anymore. And I want to legally separate on today. I think that's a good real life practice tip.
Perfect. I am not seeing any, wait. Okay. Yep. I am not seeing any other questions at the
Okay.
moment. So I think I'm going to go ahead and say thank you to all of you for joining. Again, if you have your hand raised, you can unmute. Um, Thank you to all of you for joining us, with a very, very special thank you to Manisha for presenting and for answering all those questions, all those great real world examples. All the links that Manisha mentioned throughout her presentation are in the chat. I'm gonna leave it for some talk for a second. So if you need a copy and paste, please do that. If you would like to review anything that was discussed, a copy of this presentation will be available on our Facebook page immediately following the end of this presentation. You will be able to access that Facebook for about 30 days, and then in about a week you should be able to access this recording at any time on our Legal Aid's YouTube page. If you would like to register for one of our other Listen and Learn presentations, we don't have any more for 2025, but they have already been posted on our Eventbrite page for 2026. You can do so on our website at www.legalaidnc.org/clinics. Thank you all so very much, and I hope everyone has a wonderful rest of their afternoon.